You are on bond for a tampering case, and you've now picked up a burglary of a motor vehicle. We are going to do probable cause.
Welcome back to the channel, where we break down the most shocking courtroom moments you won't believe until you see them. Today we're stepping into Harris County, Texas, where a defendant on bond for a tampering charge is back in court this time, accused of burglary and breaking into a motor vehicle. But here's where it gets wild. Police say witnesses actually caught him in the act. Video evidence was submitted, and the chase that followed looks straight out of a movie. Let's just say he has zero tolerance for repeat offenders. In this breakdown, we'll uncover how the legal system handles defendants who don't learn their lesson, why bond revocation is such a big deal, and what this means for public safety. Trust me, this case is packed with tension, contradiction, and some heated courtroom exchanges. Stick around, because by the end, you'll see exactly why this judge's reaction left the courtroom stunned. Let's get into it.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 14th, 2025, in Harris County, Texas, a law enforcement officer was flagged down.
Right away, the judge outlines the defendant's rights and begins reviewing the probable cause. This is where things get serious. Probable cause is the legal standard that determines if there's enough evidence to move forward with charges. And in this case, the officer isn't just relying on one person's word. There are multiple witnesses, and even cell phone video. That's about as strong as it gets. Think about it. Eyewitnesses plus digital proof. The law doesn't require absolute certainty at this stage, just enough evidence to justify prosecution. Do you think that's fair? Should a video clip and witness statements be enough to lock someone into a criminal trial?
By the complaining witness. The complaining witness advised the officer that a male had just broken into the complaining witness's motor vehicle and drove off in a different motor vehicle. Another witness observed the defendant break into the complaining witness's motor vehicle and provided cell phone video to the police. Additionally, the complaining witness observed the defendant break into his motor vehicle and chase the.
This is a turning point in the hearing. Cell phone video in criminal cases has become one of the most powerful tools for prosecutors. Unlike in the past, where it could be one person's word against another, video creates a visual narrative. Jurors can actually see, but remember, video evidence isn't always perfect. It can be shaky, cut off important context, or miss the moments before and after the incident. Still, in this case, paired with witness testimony, it's devastating. For the defense, let's be honest, when the court hears we have video of the crime, the defendant is already on the back foot.
Defendant through the parking lot. The officer pursued the defendant on foot. The defendant was detained and positively identified by both the witness and the complaining witness. The defendant admitted.
And here's the jaw dropper: the defendant admitted to breaking the window. In criminal law, a confession is considered one of the strongest forms of evidence, but it's not always the full story. Sometimes defendants confess under stress, or to minimize charges, or even because they think it'll help them in the long run. But combined with witnesses and video, this admission seals the deal. It raises the question, was this desperation, arrogance, or just a slip-up? Either way, it's a legal knockout punch for the prosecution.
To breaking the complaining witness's window.
Time of day or night was this? Or was it during the day?
It's in the daytime, it appears, Your Honor, but also, like when you read the summary, it looks like an officer detained him on a bicycle and that he was wearing different clothes.
Now, here's where things get a little messy. The officer mentions the defendant was detained on a bicycle, wearing clothes that didn't match the original description. The defense could argue this creates doubt. After all, if the suspect was wearing different clothes, how can they be sure it's the same guy? But prosecutors know this tactic, and they'll argue that changing clothes after a crime is classic behavior to avoid being recognized. Plus, the drive-by identification confirmed him. What do you think? Does ditching clothes sound like a guilty move, or could this actually weaken the case?
From the description of the foot pursuit, that clothes were ditched.
I don't know.
So then they did a drive-by identification of the suspect.
Mr. Robinson, what is the one thing I asked you not to do? The one thing I asked you not to do. Not.
Listen to the judge here, he's not holding back. The one thing he asked the defendant not to do was reoffend, and yet here we are. Judges take this personally, because bond is essentially a promise. Stay out of trouble and we'll let you wait for trial at home. When a defendant breaks that promise, it's like spitting in the face of the court. This reaction from the judge isn't just anger, it's about protecting the credibility of the entire bond system. Without it, the courts would collapse under the weight of keeping every single defendant in custody.
Be a danger to my city or pick up a new case. You've now picked up a very I'm going to find that there's probable cause.
And here comes the hammer. The judge finds probable cause and immediately revokes the defendant's bond. This is huge. Revocation means the defendant no longer has the luxury of waiting for trial outside jail. On top of that, the judge orders a GPS ankle monitor, meaning every move will be tracked. The restrictions are tight. No alcohol, no drugs, no weapons, and absolutely no contact with the witnesses. This isn't just about punishment, it's about control. The court is making sure this defendant has zero chance of slipping back into the community undetected. Question for you. Do you think GPS monitoring is an effective safeguard, or just a temporary fix?
To go forward with the case, and I'm now going to put a monitor on you so I know where you are at all times. If you get out of custody, because now I'm revoking your bond, you will go to jail. If he gets out, GPS monitor not to go within 500 feet.
He has a GPS monitor on him.
Putting him in custody. No alcohol, no drugs, no weapons, no going within 500 feet of where the complaining witness lives, work. And I'm going to tell you now, because I don't know if you're going to get out, but if you do, you and
This warning is brutal but crystal clear. If the defendant reoffends again, the judge will go ballistic on all his bonds. That means stacking consequences to the point where freedom isn't even on the table. Judges rarely speak this strongly, unless they feel their trust has been betrayed. And let's not forget, the judge isn't just protecting himself here, he's protecting the entire city. It's a message to the courtroom, to the defendant, and honestly to the public watching this unfold. If you endanger my community again, you'll face the harshest penalties possible. That's as serious as it gets.
Endanger my city again, I'm going to go ballistic on all of your bonds. Do you understand? Goes with you.
I have a,
Judge, I have no reason to doubt that,
Scott, just, there's no need. It's done.
part of the time.
And that's where this case leaves us. A defendant who was already on bond for tampering charges now faces burglary and motor vehicle charges, caught on video, identified by multiple witnesses, and even admitting part of the crime. The judge's patience completely gone, bond revoked, GPS monitoring ordered, and one of the harshest courtroom warnings we've seen in recent weeks. This case is a powerful example of how the justice system balances second chances with public safety. Now I want to hear from you. Was the judge too harsh, or exactly right? Drop your thoughts in the comments below. And if you found this breakdown as intense as we did, don't forget to smash that like button, share this video with others who love courtroom drama, and subscribe for more jaw-dropping legal breakdowns every week.